Namaste and welcome to Legal Baatchit, your prime destination for untangling the threads of Indian legal fabric. Today, we're set to dissect a key piece of legislation in corporate insolvency, Section 11 of the Insolvency and Bankruptcy Code, 2016. This isn't just about who can't file for insolvency, it's about protecting the process from abuse. Section 11 acts as a gatekeeper, ensuring that the corporate insolvency resolution process is initiated only when it's absolutely justifiable. Join me as we embark on a journey through the legal landscape to understand the barriers laid out in Section 11 and their significance in the corporate world. Let's dive into the legal deep end and unravel the layers of Section 11 together. The role of Section 11 within IBC. Section 11, perhaps one of the most crucial elements within the IBC, operates as a regulatory filter. The code itself is a complex machinery designed to balance the resolution of insolvency with the recovery of debts in a time-bound and efficient manner. However, without Section 11, this machinery could potentially be misused, allowing for the initiation of insolvency proceedings by entities that might do so out of turn, with malafide intentions, or in a manner that undermines the orderly process of debt recovery. The role of Section 11 is to insert a series of checks within the IBC framework that serve several key functions. Primarily, it works to prevent the same corporate debtor from being subjected to multiple insolvency proceedings either simultaneously or in rapid succession. This is crucial because without such a provision, corporate debtors could be trapped in a cycle of never-ending insolvency proceedings, which would not only be detrimental to the debtor's economic health but would also clog the adjudicating authority with redundant cases. Section 11 also ensures that the IBC's mechanisms are not leveraged as tools for coercion or harassment by creditors. By disqualifying certain creditors, specifically those involved with a debtor already under a pre-packaged insolvency resolution process, the code aims to safeguard the debtor from being unduly pressured by creditors who may attempt to use insolvency proceedings to force settlements or renegotiations of existing arrangements. Further, Section 11 respects the sanctity of the resolution process by ensuring that entities which have previously had a resolution plan approved, or have been in breach of one, cannot prematurely drag the corporate debtor back into insolvency. This underscores the finality and binding nature of resolution plans and honors the concerted effort of all stakeholders who participated in reaching that resolution. Moreover, this section reinforces the temporal sanctity of the resolution process by imposing a 12-month moratorium period after the completion of a corporate insolvency resolution process before another can be initiated. This cooling-off period is crucial for allowing the corporate debtor to attempt a genuine turnaround without the overhang of imminent insolvency proceedings. Lastly, the inclusion of Explanation I and II further clarifies the scope of the section. Explanation I expands the definition of corporate debtor to include corporate applicants, thus broadening the section's reach. Explanation II is particularly insightful. It clarifies that while certain corporate debtors are barred from initiating an insolvency process under specific circumstances, this does not preclude them from initiating a process against another corporate entity. This clarification is vital as it ensures that a corporate debtor's right to seek remedy for insolvency against another corporate is not unjustly curtailed due to their own insolvency status. In conclusion, Section 11 is a testament to the legislative foresight embedded within the IBC. It is crafted to prevent the abuse of the insolvency process and to ensure that it remains a path of last resort for the resolution of genuine financial distress, thereby preserving the integrity of the resolution process and safeguarding the interests of all stakeholders involved. Detailed analysis of Section 11. Clause A. Corporate Insolvency Resolution Process, CIRP, and Pre-Packaged Insolvency Resolution Process. Clause A. Explicitly mentions two distinct types of insolvency proceedings, the CIRP and the Pre-Packaged Insolvency Resolution Process. The CIRP is a formal process initiated either by the debtor or the creditors, where an interim resolution professional takes control of the debtor company, constitutes a committee of creditors, and oversees the development and approval of a resolution plan. This plan aims to restructure the company's debts and revive its operations. The pre-packaged insolvency resolution process, introduced as an amendment, is a hybrid mechanism that combines the speed of out-of-court settlements with the legal sanctity of the court-supervised insolvency process. It's designed for swift resolutions where the stakeholders agree to the terms beforehand, and then seek the approval of the adjudicating authority. This process is less disruptive and often seen as a more efficient way to resolve insolvency for smaller companies or those with less complex debt structures. Clause A. Inclusion of financial and operational creditors. Clause A. reflects an important amendment that brought financial and operational creditors under specific restrictions. Financial creditors, typically banks or bondholders, and operational creditors, like suppliers or service providers, play different roles in a company's capital structure. Including them in the ambit of this section is a strategic move to prevent multiple insolvency applications from creditors who might have differing interests and priorities, ensuring that a debtor undergoing a pre-packaged insolvency process is not overwhelmed by simultaneous insolvency applications. Clause B. The cooling off period. The cooling off period is a thoughtful addition to prevent the abuse of the insolvency process. It provides a moratorium for the debtor, during which it is insulated from the pressures of insolvency proceedings. The rationale is to give the company a chance to stabilize and implement the resolution plan. However, there's a fine balance to be maintained here, protecting the debtor while ensuring that genuine cases of insolvency can still be addressed. Legal precedents and case laws in this context often hinge on the specific circumstances of each case, emphasizing the need to maintain the sanctity of the resolution process while also safeguarding the legitimate interests of the creditors. Clause B. Implications of a recently approved resolution plan. Clause B. further fortifies the position of a corporate debtor who has successfully come out of insolvency with an approved resolution plan. It's a period of immunity from new insolvency proceedings, allowing the debtor and its stakeholders to focus on executing the plan without the looming threat of being pulled back into insolvency. The implications are significant, as this clause enforces the finality and authority of the approved plan, signifying a fresh start for the corporate debtor. Clause C. Enforcement and consequences of violating resolution plan terms. The enforcement of Clause C is crucial, as it directly affects the credibility of the insolvency resolution framework. Violating the terms of a resolution plan is a serious breach that can lead to legal sanctions, including the potential for the corporate debtor to be pushed back into insolvency proceedings or for creditors to lose their right to recover their dues. The consequences serve as a deterrent against non-compliance, ensuring that all parties adhere to the agreed-upon resolution plan. Clause D. Finality of a liquidation order. Finally, Clause D speaks to the terminal nature of a liquidation order. Once an entity enters liquidation, its assets are to be sold off to pay creditors, and the entity ceases to exist as a going concern. This clause underscores the definitive endpoint of a corporate debtor's life cycle under the IBC. The finality implied by this clause is central to the insolvency resolution process, ensuring that there is a clear and conclusive outcome to proceedings, thus providing certainty and closure to creditors and other stakeholders. In essence, Section 11 weaves a protective tapestry around the corporate debtor, safeguarding the insolvency resolution process from potential abuse and ensuring that it remains a tool for genuine financial reorganization and not a weapon for creditor coercion or debtor evasion. Each clause has been meticulously constructed to balance the interests of all parties involved in insolvency proceedings, creating a comprehensive framework that supports both recovery and resolution. Clarifications through explanations. The clarifications through the Explanation I and Explanation II in Section 11 of the Insolvency and Bankruptcy Code, 2016, are essential for a comprehensive understanding of the restrictions imposed by this section. Let's delve into these explanations in detail. Explanation I. Inclusion of corporate applicants in the definition of corporate debtor. Explanation I widens the scope of what constitutes a corporate debtor. In the context of the IBC, a corporate debtor is typically understood as a corporate entity that owes debt to others. However, Explanation I expands this definition to include corporate applicants as well. A corporate applicant can be the corporate debtor itself, its members, or its creditors initiating the insolvency resolution process. By including corporate applicants within the ambit of corporate debtor, the Code ensures that entities that are actively involved in the insolvency process, and not just passive debt-owing entities, are also subject to the restrictions of Section 11. This inclusion is significant because it prevents companies from potentially bypassing the restrictions by filing for insolvency resolution as applicants rather than as debtors. It maintains the integrity of the insolvency process by ensuring that the entity involved in the process, whether as a debtor or as an applicant, cannot re-initiate insolvency proceedings under the circumstances laid out in Section 11. Explanation 2. Ability of barred corporate debtors to initiate proceedings against other corporate debtors. Explanation 2 addresses a potential gray area that could arise from the restrictions in Section 11. Without this explanation, one could interpret Section 11 as barring a corporate debtor from initiating any insolvency resolution process if they fall under the specified restrictions. However, Explanation 2 clarifies that such barred corporate debtors are not prevented from initiating insolvency proceedings against other corporate entities. This clarification is important for several reasons. Firstly, it ensures that a corporate debtor who is under one of the restrictions of Section 11 still retains the right to recover debts from other corporate entities through the insolvency process. It maintains a corporate debtor's ability to seek redress and not be hindered by its own insolvency status from protecting its financial interest in other corporate entities. Secondly, it preserves the principle of mutuality in insolvency proceedings. Just because a corporate debtor is undergoing its own financial restructuring does not mean it should lose the power to initiate proceedings if another corporate debtor owes it a significant debt that could affect its own recovery and financial health. In summary, explanation I and 2 to Section 11 are pivotal in ensuring that the restrictions are applied fairly and without unintended consequences that could impair the rights of corporate entities to participate in the insolvency resolution process. These explanations provide the necessary legal nuance to the section, ensuring that the restrictions serve their intended purpose without overreaching. Case studies and examples. The case studies where Section 11 of the Insolvency and Bankruptcy Code has been applied. Let's dissect the intricacies and judicial reasoning in the decisions of Abhay and Manodhane vs Gupta Coal India Private Limited and Amey Laboratories Limited versus Kotak Mahindra Bank. Abhay and Manodhane vs Gupta Coal India Private Limited. In this case, the core issue centered on the rights of a liquidator in the context of Section 11 of the IBC. The NCLAT had to interpret whether the liquidator could initiate the corporate insolvency resolution process, CIRP, against other corporate debtors after a liquidation order had already been passed against one debtor. The tribunal referred to Section 33(5) of the IBC, which prohibits any legal proceedings against a corporate debtor once a liquidation order is made, except by the liquidator with the court's approval. The tribunal observed that while the liquidator has the authority to maximize the assets of the corporate debtor by initiating legal proceedings for recovery, initiating a fresh CIRP is not within the scope of this authority. This is because Section 11(d) expressly bars a corporate debtor undergoing liquidation from initiating or having a CIRP initiated against it. The judgment in this case reinforced the sanctity of the liquidation process and ensured that the provisions of Section 11 are strictly adhered to. Amey Laboratories Limited versus Kotak Mahindra Bank. Amey Laboratories presented a complex scenario where the company itself sought to initiate a CIRP under Section 10 of the IBC, despite there being an existing winding-up order against it. Kotak Mahindra Bank opposed the petition, invoking Section 11(d), which prevents a corporate debtor under liquidation from initiating or undergoing a CIRP. The legal contention revolved around whether Amey Laboratories, facing liquidation, could utilize the CIRP mechanism ostensibly as a tool to stall the enforcement of the rights of its secured creditors. The NCLAT was tasked with evaluating the motives behind the petition and the legal standing of the company to file for CIRP under the circumstances. The tribunal's decision in this case is particularly illuminating, as it showcases the interplay between the winding-up process and the CIRP. It also touches upon the broader theme of the IBC's intent to streamline and expedite the insolvency process while preventing its misuse by corporate debtors seeking to evade their obligations. The case represents a significant precedent in understanding the limitations imposed by Section 11 on corporate debtors already under the duress of liquidation. Both cases serve as critical examples of the judiciary's role in interpreting the IBC and ensuring that its provisions are not exploited. They demonstrate the balance that the code strives to achieve between the efficient resolution of insolvency and the prohibition of its misuse, thus upholding the integrity of the insolvency resolution process in India. Implications and consequences. Section 11 of the Insolvency and Bankruptcy Code, IBC, 2016, plays a crucial role in shaping the corporate insolvency landscape in India. Its provisions contribute to the ecosystem by instilling a disciplined framework for insolvency and liquidation processes, aligning with the broader objective of promoting ease of doing business. In-depth implications for the corporate ecosystem. Strategic filings and legal framework. Section 11 deters strategic filings that aim to abuse the insolvency process. By disqualifying certain entities from initiating the insolvency resolution process, it prevents corporate debtors from filing for insolvency as a delay tactic or to evade financial responsibilities. This aligns with the overarching framework of the IBC, which is to consolidate and amend the laws relating to reorganization and insolvency resolution in a time-bound manner. Financial discipline and credit culture. The restrictions imposed by Section 11 encourage financial discipline among corporate entities. Knowing that they might be barred from accessing the insolvency resolution process if they fail to comply with the terms of a resolution plan or if they are already under liquidation, companies are incentivized to operate more responsibly and maintain a healthy credit culture. Judicial efficiency and resolution focus. By filtering out ineligible applicants, Section 11 helps in reducing the burden on the judicial system, allowing adjudicating authorities to focus on genuine cases, thereby enhancing the efficiency of the resolution process. Global best practices in insolvency and Section 11's alignment. Uniformity in insolvency proceedings. Globally, insolvency laws aim to create uniformity and predictability in insolvency proceedings. By setting clear restrictions on who may initiate insolvency proceedings, Section 11 brings the Indian insolvency framework in line with international practices, which typically include similar prohibitions to prevent misuse of the system. Protection of creditors' rights. International best practices in insolvency underscore the protection of creditors' rights. Section 11 reflects this principle by ensuring that the insolvency process is not leveraged by defaulting debtors to escape their obligations, thus safeguarding the interests of creditors. International standards and harmonization. The IBC, with provisions like Section 11, seeks to harmonize India's insolvency framework with international standards, such as those advocated by the World Bank's Principles for Effective Insolvency and Creditor-Debtor Regimes and the UNCITRAL Model Law on Cross-Border Insolvency. Promoting cross-border insolvency cooperation. As the Indian economy integrates globally, adherence to international standards, including those related to insolvency, becomes essential. Section 11's criteria for initiating insolvency are steps toward fostering an environment conducive to cross-border insolvency cooperation. Investor confidence and market stability. By providing a structured and predictable insolvency process, Section 11 enhances investor confidence and contributes to market stability. This is critical for attracting foreign investment and is in line with the goals of the G20, OECD principles of corporate governance. In conclusion, Section 11 is a well-contemplated provision in the IBC that ensures the insolvency resolution process is not misused. It brings India's insolvency regime closer to global standards, promoting an environment of financial discipline and fairness, and contributes to the overall health and stability of the corporate sector. Conclusion. As we conclude our in-depth exploration of Section 11 of the Insolvency and Bankruptcy Code, IBC, 2016, let's encapsulate the multifaceted implications and the profound understanding it offers to stakeholders in the corporate insolvency domain. Comprehensive implications of Section 11. Selective admissibility. Section 11 sets precise eligibility criteria for initiating the insolvency process. This selectiveness is pivotal in preventing the insolvency mechanism from being exploited by corporate entities as a tool for debt evasion or as a strategic ploy in corporate battles. Legislative intention and judicial scrutiny. The judicial scrutiny observed in cases applying Section 11 reflects the legislative intention behind the IBC. The court's interpretations enforce the law's spirit, ensuring that the insolvency resolution process is a path for recovery and restructuring, not a loophole for escape. Enforcement of corporate morality. By imposing a moratorium on entities that have recently undergone a resolution process or are in liquidation, Section 11 enforces a form of corporate morality. It mandates that companies and their management take their financial responsibilities seriously and consider insolvency as a last resort rather than a first response to financial distress. Financial prudence and credit discipline. Section 11 indirectly promotes financial prudence and credit discipline among corporate entities. It discourages reckless borrowing and financial mismanagement by imposing consequences that could bar access to the insolvency resolution process if abused. Global Insolvency Protocols. In alignment with Global Insolvency Protocols, Section 11 safeguards the interests of creditors and shareholders by preventing debtors from engaging in dilatory tactics. This alignment with international best practices reinforces India's commitment to maintaining a resilient and credible financial system, conducive to domestic and international trade and investment. Understanding Section 11 for stakeholders. Corporate debtors. For corporate debtors, Section 11 provides a clear framework for understanding the repercussions of their financial and operational actions. It is a cautionary boundary that encourages the pursuit of insolvency resolution only under genuine circumstances of distress. Creditors and investors. Creditors and investors can interpret Section 11 as a protective measure. It reassures them that their financial interests will be safeguarded against debtor companies that might otherwise repeatedly file for insolvency to defer debt repayment. Legal practitioners and academics. For legal practitioners and academics, Section 11 offers a rich tapestry of jurisprudential thought. It is a subject of study and application that calls for nuanced understanding and interpretation, particularly when dealing with complex corporate insolvency cases. Judiciary and adjudicating authorities. The judiciary and adjudicating authorities rely on Section 11 to uphold the IBC's integrity. It equips them with the legislative mandate to sieve out non-meritorious insolvency applications, thus preserving judicial time and resources for cases warranting resolution or liquidation. Policymakers and regulators. For policymakers and regulators, Section 11 serves as an example of how targeted legislative provisions can streamline and improve financial and insolvency regulations, echoing the broader economic reforms and governance ethos. In conclusion, Section 11 of the IBC is a testament to the robust, thoughtfully constructed insolvency framework of India. It underscores the necessity of responsible financial governance, upholds the interests of creditors, and aligns with international standards, thereby enhancing confidence in India's corporate and financial systems. Understanding its nuances is crucial for all stakeholders engaged in the corporate insolvency resolution process. And as we wrap up our detailed walkthrough of Section 11 of the IBC, we turn the floor over to you. What are your thoughts on the impact of these provisions? Have you come across any interesting cases or insights related to insolvency proceedings? Drop your comments below. We're keen to hear your opinions and answer any questions you might have. If you found this analysis helpful, please do us a favor, hit that like button, subscribe to Legal Baatchit, and share this video with your peers and colleagues who might benefit from this legal deep dive. Your support enables us to continue producing comprehensive legal content like this. Thank you for investing your time with us today. Your engagement and curiosity in legal matters make all the effort put into these discussions worthwhile. We're dedicated to providing you with insightful and thorough legal content, breaking down complex legal jargon into something accessible and interesting. Remember, whether you are a legal professional, a student, or simply someone with a keen interest in the law, Legal Baatchit is your go-to channel for getting to the heart of India's legal landscape. Until next time, keep the conversation going, and stay legally informed. Farewell, and take care.